So thank you. So nothing, or at least I've had confirmation that those behind me are happy with how we put the apportionment issue. So if, as a matter of fact, the tribunal find it's on provision of plant, it's allowable. If they find it's not allowable. If they find it's on both, and even maybe something else, then you would do an just and reasonable apportionment.
Yes, I see.
Thank you. And other than that, those are my submissions.
Thank you very much. Mr. Jones.
My Lords, I'll deal with the grounds in the order in which I learned a friend dealt with them, starting then with ground 1 and beginning with design costs. My learned friend's central thesis on this point seems to be built on the proposition that the word provision in section 11.4 means supply for use. But in the end, there is no authority to support that proposition. Indeed, what authority we do have seems entirely to contradict it. If your Lordships would take up Barclay Curl in tab 10 of the authorities Bible, please, at page 84. Within Lord Reed's speech, just at letter E, Lord Reed considered that the cost of provision of plant can include more than the cost of the plant itself. And then even more explicitly in Lord Guest's speech on page 90 of the authorities bundle, between F and G, Lord Guest states that the word provision, in inverted commas, must cover something more than the actual supply. So in my submission, the term provision cannot be equated with the actual supply of the plant, and my learned friend's addition of the words for use after supply do not, with respect, rescue her proposition. Now, from that foundation, my learned friend argues that the expenditure on design cannot count as expenditure on the provision of plant because supply for use is what happens when the design is turned into reality, and everything before that, she argues, is just decision making. And with respect, that distinction is unsound. In addition to being based on the flawed premise that provision equates to the supply of the plant, the positioning of the dividing line doesn't withstand scrutiny. It now appears to be common ground that the correct approach is that one starts with the plant in question, which in fact came into existence, and then one looks back with the benefit of hindsight, as my lord observed, to see what was incurred on its provision. Now, using hindsight, we can see that immediately before the fabrication stage, there was a design stage, at the conclusion of which the decision-making stopped and a final design was created to be handed over to the fabricator. Now, that final design is not about decision-making. It was about creating a specification so that the plant could be brought into existence. Now, my learned friend has disavowed the idea that there's any relevant distinction between intellectual contributions to the provision of plant and physical or manual contributions. So the fact that the final design stage involved intellectual effort rather than manual labour is irrelevant. So it would seem to follow in my submission that the final design stage should be qualifying on the logic of HMRC's case. But that means that the bright line distinction that they seek to uphold is no longer tenable. Moreover, the decision-making part of the process is still part of the design phase, without which the plant cannot come into existence at all. And there's also the point that factually, in the real world, the distinction between decision-making and design and construction that HMRC seem to compartmentalise into discrete parts of a single chain are in reality mixed up. It's likely to be, particularly with a project like designing, constructing, installing an offshore wind farm, it's likely to be an iterative one. The decision-making stage may well continue into the manufacturing stage or into the installation stage. So in reality, there isn't the kind of bright line that HMRC would seek to introduce into the test. In addition to that is the point that on the authorities, such as we have them, it has been held to be the case that costs on the advice given to assist decision-making as to what to acquire are still costs on the acquisition of, in that context, in Samarkand, the particular item. And we also have authority to the effect that there is no substantive distinction between the concept of the acquisition of an item and expenditure on the provision of an item. So all the indicators in my submission are against HMRC's central thesis on that point. There are other inconsistencies that are exposed when one probes that boundary line. The designs in question here were necessary in order for the plant to be fabricated. In other words, without them, the plant couldn't have come into existence. And so, to borrow from the words of Lord Guest in Berkeley Curl, that design stage was a necessary preliminary to the construction of the plant. The difference between what was being considered in Berkeley Curl and what's being considered here is a difference between excavation on the one hand and design on the other. But in a context where there is no distinction being drawn between physical labour and intellectual inputs into the provision of plant, that is not a relevant distinction. However, the revenue say that that design stage, without which the plant simply could not have come to exist, cannot qualify. But it also appears to be their position, because they don't say that their manuals are wrong in law, that site overheads, like insurance, which as far as I can see does not provide plant in any direct or obvious way, are capable of qualifying as being expenditure on the provision of plant. And with respect, that is not a coherent position. Now, still dealing with Berkeley Curl, I rather suspect the upshot of this is that we don't get a great deal of assistance from it, but there was a question about what was within the scope of the expenditure in Berkeley Curl. If it would assist the court or be of interest, we do have copies of the tax cases report, which includes the Special Commissioner's decision, which does set out the expenditure. I'm very happy to take your lordships through it, although one doesn't glean a huge amount from it.
I think we might as well see that.
I'd certainly like to have it, even if we've no need to read it out to us, probably.
Well, I'm more than happy to take your lordships through it. There are a couple of points that one can draw from it, but ultimately one's left to speculate. If I might hand up copies of that. So on the second page, within the case stated, starting at letter D, there's a summary description of the expenditure in question. And the Special Commissioners described that in the 4 years ended 31st December 1965, the company incurred expenditure amounting to 1 million odd on the provision of number 3 dry dock and associated works. Of this total, 120,986 was agreed between the parties not to relate to the number 3 dry dock, leaving the sum of 930,596 relating thereto and made up as follows. And you've got cost of excavation of land for number 3 dry dock, 186,928. Cost of concrete work, etc., used in constructing that dock, 500,380. Cost of ancillary plant, 243,288, leading to that figure. So that, and there's an extract from the accounts later. I'll show you lordships that. That would appear to be the totality of the expenditure by the company on the dry dock, which one might assume includes the costs of design and so on. It's also worth noting, if not just as a point of interest at H, that there are witnesses named there who gave evidence, including an individual with a very impressive CV who was a member of the Institute of Civil Engineers, a member of the Institute of Structural Engineers, a member of the Institute of Water Engineers, a member of the Institute of Engineers and Shipbuilders, and a partner in the firm of chartered engineers responsible for the building of the number 3 dry dock, which does rather imply that there were some serious professional inputs into the construction of the plant. And then just to note on the following page, on page 3, subparagraph 3, there's a list of documents that were proved or admitted before the Commissioners, and item number 3 is an analysis of the company's expenditure on number 3 dry dock at its ship repairing yard, and number 5, plans of the number 3 dry dock. And then at the bottom of that page, there is subparagraph 4, the opening words of which record that the number 3 dry dock was started in 1962 and was built and equipped by the 31st of December 1965. Now, I just mentioned that because it links to a point of fact that I'll come on to when I deal with the facts of this. Projects of this nature have long lead times. Berkeley Coal is no exception. And the company in Berkeley Coal was incurring costs, it seems, all the way along that 4-year timeline. Just moving forward to page, the 6th page, which within the report is page 226. There's an extract of the balance sheet. And there's extracts from the balance sheet for 1962, 1963, 1964 and 1965. And then then at subparagraph 12, there is a reference to what was referred to earlier as Exhibit 3, which is a breakdown of the company's expenditure. And it's stated that that exhibit shows that the total net expenditure, after taking into account a grant from the Board of Trade, of the company on the provision of number 3 dry dock over the 4 years ended 31st December 1965 was the £1 million figure that we saw at the beginning of the case stated. Of this total, there's 120 odd thousand which is agreed not to relate to the dry dock at all. Then there's a balance of expenditure which breaks down so that there's an amount that sums to 243,288 in relation to items which themselves were accepted as being plant or machinery. There was no dispute about those items. And there's one grain of an indication within that is that there is allocated at the bottom of that list amounts of professional charges relating to the above items, which might be taken to imply that the costs of the professional charges are spread between the items within that total figure of 900 odd thousand. And then there's an extract of a letter from the Board of Trade which advised the company that a grant was going to be made, and within that it refers to the cost of providing a building, this is at letter H, cost of providing a building of the size and nature described in the plans and specifications produced to the Board of Trade, which of course implies that such plans and specifications have been drawn up and provided, including the cost of building work shown in your plant and machinery application, i.e. the dock gate, pumping plant, etc., and the 50,000 for the design and supervision of the building. Now, what we don't know is to what extent that formed part of the costs that were in issue. And there, I think, the trail runs cold in terms of the case stated. So there are indications that there were planning and design costs built into the total costs, and it would appear to be a fair assumption that the company will have brought into its balance sheet, as the companies did here, the costs of building the dock, which would include the costs of design and supervision of the building work. But there is no more granularity in terms of the excavation costs and the tantalising etc. in the line item related to the concreting. So for what it is worth, that is as far as I've been able to take it. There is also the point about McVeigh. My learned friend did clarify the position. I don't detect that there is a particular divergence between the parties in relation to that. In case it is helpful to you lordships, it is worth looking at the terms of section 16 of the Finance Act, which is set out in the Special Commissioner's decision. I think it's page 73 within tab 9. So the text of section 16, as it stood at the time, is set out there, and it provides for an allowance, the investment allowance, made in respect of capital expenditure on new assets incurred after 1954, and the allowance is equal to 3/10 of the expenditure made in addition to an initial allowance under Chapter 2 of Part 10 in respect of the expenditure on the provision of new machinery or plant. So one might infer that the extra incentive was to buy new plant or machinery, hence the enhanced allowance. And there is a saving in relation to subparagraph C, where the expenditure on new machinery or plant is allowed to be deducted in computing profits or gains for the purposes of income tax. It shall nevertheless be treated as capital expenditure for the purposes of this subsection, if it would be so treated for the purposes of the said chapter 2, but for the deduction. So that, and as my learned friend rightly said, there did appear to be a dispute between the parties in McVeigh before the commissioners as to whether it was capital expenditure, and then that that was conceded, I think, or accepted when it went to the High Court. But it is right to say, as my learned friend has noted, that the conclusion of the High Court is that all of the expenditure on designs qualified for that investment allowance as being expenditure on the provision of new plant. There was no distinction between designs that were used immediately and designs that were put on the shelf for use at a future committee meeting. That was all I was proposing to say about McVeigh. I'm going to turn then to deal with the installation part of this aspect of the first ground. Now, as a starting point, my learned friend confirmed that HMRC are content to take as helpful the definition of installation found in SSE that we looked through via the medium of Urenco, and to use that as a working definition for the purposes of this aspect of the code. But then HMRC's position seemed to be that any attempt to examine the scope of that term further was out of bounds or off limits, and was relatedly an impermissible attempt to try and expand the scope of what's qualifying. So we can take that as the working definition, but don't try and probe that definition any further, because that would be trying to expand the scope of what's qualifying. Well, with respect, that ship had sailed by the time the House of Lords handed down Barclay Curl, if not earlier, because it is recognised at the highest level that provision can include installation. Now, that being so, why, one might ask, can the statute be interpreted that far but no further? It is surely permissible to inquire and explore what that admittedly judicially recognised concept of installation means here. Otherwise, it's difficult to see how the law can be developed. And if one thing is clear, it is that there is certainly room here for further judicial guidance on what "on the provision of" means. Now, there was a question raised by my Lord Justice Zacaroli, of my learned friend, as to whether costs that were charged by a third-party installation subcontractor who had undertaken studies of the kind that were undertaken here, for example, to check for unexploded ordnance, would count as expenditure on the provision of the plant. And my learned friend's answer to that seemed to be that if the installer comes to do the act of installation and at that time carries out that check, then that would be qualifying. And that was said to be because by then the installation had started. Now, if I've understood that correctly, then that seems to boil down to a timing point. I think even HMRC would accept that checking for things like unexploded ordnance has to be done before the monopile is driven into the seabed. There isn't much point checking after that stage. Now, if that's qualifying, why does it matter, given that it's accepted that the time of expenditure doesn't bear on the question of whether it was on the provision of the plant? If that counts, then why does it matter whether the check is done 5 minutes before, or 5 days before, or 5 months before? What matters is the nature of the expenditure and the role that it plays in the provision. So the fact that some of the checks are done here in surveys many months before doesn't alter their nature. And of course, there is very good reason why they do the checks many months before. It's because it's no good finding out that there's an unexploded bomb at the site you'd like to drive the monopile into 10 minutes before you're due to hammer it into the ground. And then in relation to the manuals, just dealing with the point about the expenditure on the construction of a building, my learned friend had repeatedly said, don't worry about what we say there because this is a different regime. Well, it's a different part of the same act. It's actually the part that immediately follows Part 2. It's Part 2A. Just for your Lordship's reference, the relevant section, as far as I can see, is section 270, capital B, which refers to capital expenditure incurred on construction. And the key part reads, if capital expenditure is incurred on the construction of a building or structure, there's a limb B, which is about whether the building has been sold, then the tail piece says that the capital expenditure is qualifying capital expenditure. So the key phrase, expenditure incurred on the construction of a building, remains in place. And as I've submitted in the course of my submissions, the terminology which Mr. Justice Brightman and Lord Donovan thought was analogous to the terminology found in relation to plant and machinery allowances is exactly the same. So the analogy holds good. And my learned friend took the court to J.D. Wetherspoon's, I think, to illustrate an example of where what HMRC say about architects' fees might come into play. Now, what was notable about that is that the part of J.D. Wetherspoon that my learned friend took you to, which is paragraph 66.
Just
Yes.
give us a moment.
I think Wetherspoon is at tab 21.
Yep.
And specifically, paragraph 66. Which is at page 347. That section, as is often the case when dealing with tax cases, the section numbers can be false friends sometimes because it's actually dealing with the 1990 Act. As my learned friend said, section 24 is now section 11. Section 66 is now section 25 of the 2001 Act. But the simple point is that paragraph 66 is dealing with section 66. It's not dealing with what is now section 11. So it is not an illustration of what HMRC are saying in their manuals, because what they say in their manuals relates to section 11. 66 is a deeming provision. What HMRC are talking about in their manuals, where they refer to professional fees, is the basic provision that's now found in section 11.4. So again, if HMRC are not saying their manual is wrong, then it is difficult to see how their position on what counts as expenditure on the provision of plant hangs together. Turning then, if I may, to the factual points that were made. Now, as a headline point, all chips will of course appreciate that there was an enormous amount of evidence before the FTT, and the result is a very careful decision which makes a lot of detailed findings of fact. And the devil in relation to that really is in the detail. And it's important to have regard to that detail. My learned friend Miss Parry, in attempting to summarise that, naturally couldn't get into all of the detail of the findings and so on. I don't propose to try and do that now, but there are some points of clarification that I would like to make. The first point is this, that my lord did make an observation about these costs appearing to come very early in the process. Now, some of the costs are incurred some years out from when the wind farm is commissioned. Some of the costs are not. The process of creating and constructing and installing an offshore wind farm out at sea is one that's extremely complicated and takes a long time. The companies are not sitting on their hands while they try and do this. It takes a long time because it's very difficult. Now, for example, it depends on what particular survey or study one is looking at. But for example, the metocean studies, which are dealt with in detail by the FTT at paragraph 194, which is page 472, internal page, starts at internal page 50, but there are detailed findings about the various wind farms. Just looking at that by way of an example. In relation to Walney, which starts at subparagraph 6 on internal page 52, there's a final metocean report submitted in January 2006. Now, again, without getting into all the detail of it, it takes a long time to produce a metocean report because you have to study the conditions out at sea over a significant period of time in order to get accurate results. There is then a site assessment design basis A produced in May 2009. And monopile and transition piece primary structure drawings are produced on various dates in 2010. That's under subparagraph 11. So the information that's gathered is used to inform the design, but there is a lag time, there is a lead time in doing that, but that's because it's very complicated and difficult to do. It's not because the costs don't contribute to the design and construction, provision of the wind farm, because it is a very difficult task. And likewise with the geophysical and geotechnical, and I should just note before we leave that, on internal page 53 at 196, there is a specific factual finding by the FTT who considered all of this evidence that without those studies, the specific design of the wind turbines could not be undertaken, and so they could not have been fabricated. And with the geophysical and geotechnical, which is on internal page 54, paragraph 200, as I showed the court in the course of my opening, there are stages, as the FTT finds. There's what's called the first stage, or the reconnaissance stage. There are then other rounds. This is subparagraph 5, 2 further rounds. And then there is a third round just before FID. Sorry, there's a third round that's after FID, just before construction. So those costs are incurred right before construction. So it is, with respect, not accurate to describe these costs as being incurred very early on in the project. There is a cycle, there is a life lead-in time to doing this, and they are incurred when they are incurred for good commercial reasons.
Yeah, thank you. I take that point. I think the comment I made was too broad.
I'm grateful, my Lord. But that's why I say that it is really important to bear in mind the detail of the factual findings. Now, my learned friend also said that what the appellants are trying to do is sweep in all their costs by way of the test, and that's far too broad. Well, with respect, that submission is far too broad. There are costs that are incurred at the outset in deciding whether or not this is something that they would like to do. Those have not been claimed. What was claimed was expenditure which informed the design and all the construction and all the installation of the wind farm. Those are the costs that had been claimed, not anything and everything that they could think of, but things that went to those items. And where the FTT found that the expenditure in question did not, as a matter of fact, link to design or installation, which the FTT did in relation to the desktop metocean studies at paragraph 198 and the socio-economic and tourism studies.
Sorry, just hang on. Which were your instances again? Sorry.
Well, perhaps if I just show you.
Yes.
Within the FTT decision, if one starts at 193, which is the first, my learned friend Miss Harry is right to say this is noted in the skeleton. This was also the position before the Upper Tribunal. At 193, internal page 50, in relation to the socio-economic and tourism studies, the FTT makes specific findings about the various sites and concludes at 193, I find that they do not directly relate to the design of the wind farm or the wind turbines and have no impact on the construction of the wind farm and installation of the wind turbines. So in light of that finding, the appellants did not pursue claim in relation to that item of expenditure. That's not a concession that undermines any point of principle. It's that the finding of the tribunal is that it does not contribute to those items. And likewise at 198. This is in relation to the desktop metocean studies.
I guess put the point the other way around and ask you, is there any category of expenditure which was rejected by the FTT, which you are now asking this court to reinstate?
Yes, but that is not for the reason that the FTT found that it didn't link to design. It would be because the FTT, in introducing its necessary-unnecessary design distinction, found that it did go to design, but because it wasn't necessary design, it didn't qualify. So there is a finding that it links to design.
Yes.
But because of the requirement of necessity, the FTT decided it didn't qualify. And there is also the category of expenditure that I submitted involved a logical misstep on the part of the FTT, where it is clear from the findings that it linked to design, but the FTT concluded that because there was no positive impact on the, for example, the characteristic of the turbine at that site, it could not qualify as being expenditure on design. It's the confirmation point.
Thank you. And allied to that is a sort of procedural question I've just sort of briefly raised, which is are those categories properly before us in this court?
Well,
I'm trying to remember. The position was obviously both sides appealed to the Upper Tribunal,
yes,
which then decided the case comprehensively in the revenue's favour. So since then, obviously we have the revenues appeal, and I don't think we have any respondent's notice or cross-appeal or anything of that nature.
In this court, my lord, or in
So,
the Upper Tribunal.
In this court, yes.
So the procedure was that the FTT gave its decision.
Yes.
Both sides were unsatisfied with aspects of it, so both sides appealed. The company's appeal was that the FTT was right to allow the categories of expenditure that it did allow, but it was wrong to disallow the categories of expenditure that it didn't allow, save for those two items that I just showed the court. That challenge was then pursued before the Upper Tribunal. In light of the Upper Tribunal's decision, it disallowed all the categories, and then the company's appeal from that decision, including in relation to those categories that were argued before the Upper Tribunal for the reasons that I've just given.
I was just looking to see what your appellant's notices say you want. So I think in each case you want the amendments made by the closure notices reversed. Is that right? If so, that goes slightly further than you.
Yes, if that is so, then it does go slightly further,
But
because
it encompasses everything you want.
acceptance on those two grounds.
Yes. Yes. Yes, I think in each case you do say that, but you don't go quite that far.
Yes, well, and I hope it's clear from the skeleton, there is a table that my learned friend has referred to, which replicates what was said before the Upper Tribunal, that in light of the findings that I've shown the court, the appellants don't pursue those two categories. But that's for the reasons that I've outlined.
Thank you.
Now, with respect to my learned friend Miss Parry, in giving her overview in relation to the facts, there are aspects with which the appellants would disagree in terms of that summary, and of course the facts are as found by the FTT, and there's been no challenge to those facts. But as I say, we would not agree with that summary as being entirely accurate. Just to give one example of where this detail matters, my learned friend referred to scoping. Now, her portrayal of it was as being something really very far removed from the design of the wind farm, but actually, in relation to that, there are bearings on the design of the wind farm. And this is an instance where, in my submission, the recognition of exactly what the plant is matters. This comes back to the single multiple. Now, my learned friend said, well, actually, nothing really turns on it. One might question, therefore, why HMRC contested it in the first place and then appealed to the Upper Tribunal when they lost. But it does matter, because if the focal point of the section is on the plant, and then one looks back to see what the provision, what was expended on its provision, then it's important to know what that plant is. And scoping is an example of where this matters. The FTT dealt with scoping in detail at paragraph 159, internal page 34.
Bundle page?
Bundle page 454. There are detailed findings there. There's a finding at 160 that, this is 1, 2, 3, fourth line down, there's an indirect relationship with the design of the wind farm and the wind turbines, not a direct one. And then at 161, notes that in relation to 2 of the sites, so one at Walney and one at west of Duddon Sands, the scoping exercise identified certain issues which resulted in changes to site location in the case of west of Duddon Sands and a boundary amendment in the case of Walney, and that had an impact on the design since it meant moving the wind turbines into different areas. And then the FTT says, well, there's a distinction between design on the one hand and location on the other, and then seeks to draw an analogy with a power station, and refers back to the concept of necessary design. Now, the point that's being made is that if your lordships would cast your mind back to the plan view of the wind farm site, that is the item of plant. And to be clear, certainly the way the appellants had always understood the debate and also the decisions, the item of plant is an aggregation of all the turbines and array cabling at the site. It is not an aggregation of, say, 6 turbines on a string, so that one might have then, I don't know, 8 items of plant within the wind farm. There are 3 ways one might aggregate, I suppose, looking at it sensibly. You would aggregate all the components in a single turbine. That was the revenue's way of putting it before the FTT. One might, and this is a novel point as far as I'm aware, aggregate, say, 6 turbines on an array cable string that leads back to the substation. That would be your middle position. The third position would be to aggregate all the turbines at the site. And the debate was between position 1 and position 3. Position 2 never came into it.
Do you mean before the Upper Tribunal or before the first?
Well, both. But the debate before the FTT was that was an evaluative question for the FTT, and it concluded that it was position 3. And the reason why it is clear that it concluded that it was that third position is that the essence of its decision was that one could aggregate into a single unit items which had a single purpose. And there is no sensible basis on which one could conclude that 6 turbines in a string had a different purpose from the 6 turbines in the string next door, which have a different purpose from the 6 turbines in the string next door to that. All of the turbines and cabling at the site are directed towards that single purpose, so that aggregates all of them into a single item. That was its decision, and that was what was upheld by the Upper Tribunal. And I hadn't understood until we came to this court that there was any ambiguity about that. And so when one looks at the item of plant in that way, a boundary change which affects the layout of that array is therefore a direct impact on the physical characteristics of that item of plant.
A boundary change. Boundary change of itself doesn't change the location of the cables or the turbines, presumably.
Well, it may or may not, depending on what it is, but the reference at 161 is a change that had an impact on design because it meant moving the wind turbines into different areas.
Yes, okay. But in that case, I mean, you may well be right about how you construe the first tier decision, but if you're moving turbines, does it really matter whether it's strings or the totality?
Well, it may not, but it's like saying that if you do use the analogy of a building, that you've had to move the wall of the building in a particular direction or change its angle to take into account a particular factor. Well, that is self-evidently a change in the design of the building. And that's the real analogy. Now, I suppose it may not matter.
Because I mean, equally, that logic would apply in relation to the string of cable and turbines going out in a particular direction.
Perhaps. But the point about design is that is an instance where the aggregation matters. And it is not simple as saying, as my learned friend rather sweepingly did, well, scoping's done at the start and it can't have any bearing on this, possibly. Well, actually, the findings are not to that effect, and it's important to have in mind the detail of these points, as the FTT did. There were two points of principle or submissions that were introduced by my learned friend in the course of dealing with these factual points that I'd just like to address. The first was that the studies and surveys, it was said, are not something that produce the plant. Well, that's true in the sense that it wasn't the direct product of those surveys, but that's true of the excavation in Barclay Curl. It's true of the designs in McVeigh. And the second submission, I think, was that at the time when, probably it's fair to say all of this expenditure was incurred, there was no plant. And there might never have been. So if you take a snapshot at the point of the expenditure, you transport yourself back in time, it's probably true to say that there might not be a wind farm there in due course. But that, with respect, is not the way of testing it. And there appeared to be something of a tension between that submission and the submissions that were being made by my own friend Miss Wilson in that regard. And again, the same could be said of the excavation at Barclay Curl, done by or on behalf of Barclay Curl. Might well have been the case that there might not have been a dry dock that ended up being put in the hole for one reason or another, but that is not the way one tests it, because, as I've submitted in the course of my opening, one actually starts from the position that there is plant that has been provided. If there isn't, then one doesn't get to this.
And plainly, in Barclay Curl, the plant did not yet exist. Well, probably didn't yet exist. I mean, I suppose some elements of it might have existed. But it was very clear it was going to exist.
Well, is that so, my lord? I mean, in the sense that if one is saying that hypothetically this might not come into existence.
I mean, there might have been some extraordinary event, but you don't spend a fortune digging a large hole on the off chance that you might want to put a dry dock in it.
No, but it would be true to say that it is not a foregone conclusion that there will be a dry dock in that hole. The point is that you don't test it at the point you're doing the excavation. You test it at the point you've got the dry dock, and you ask what has been expended to provide it. So the fact that at some point along the stage it might have been the case that the plant would not have been provided doesn't tell one anything. And in fact, it's probably the case you could say that in pretty much every instance. Now, just in terms of there was just one other point that my learned friend had made that I just need to say something about, which is my learned friend Miss Parry seemed to argue in effect that the Upper Tribunal was the fact-finding tribunal, constantly referred to a finding that they were entitled to make, or a conclusion they were entitled to make. With respect, that's not a position that the appellants would agree with, not least because, of course, they submit that the Upper Tribunal erred in law. The fact-finding tribunal is the FTT.
I follow that in relation to actual facts, but the Upper Tribunal considered that the FTT had erred in law, therefore it remade the decision.
Yes.
When considering whether we could interfere with their remade decision, might it not be relevant to ask whether they were entitled to make that decision?
Well, entitlement implies that there are a range of possible views, and unless they deviated in a way which meant that it obviates their effectively an exercise of their discretion, then it would stand. But they were dealing with the point of law, and actually the point of law they were dealing with was whether the FTT had erred in law. So that actually is the question ultimately, and the grounds of appeal that are put forward in relation to that are on points of law that the Upper Tribunal has made. Now, the Upper Tribunal was shown some evidence, but I emphasise a tiny, tiny part of what was a huge amount of evidence that was before the FTT. So it wasn't remade in the sense that they were taken through all the evidence again. And the reason why they remade, or the basis on which they remade the decision, was on the basis of the position in principle that they'd arrived at.
I quite follow. If you succeed in persuading us that they went wrong in law, then it doesn't really matter whether they could have been entitled to make their decision or not.
Yes, but in terms of I suppose it becomes slightly academic, but if they hadn't erred in law, then they, ex hypothesi, have arrived at the right principle. And their principle is that anything that is advice on what plant you might get or how to install doesn't qualify. And that is their characterisation of the expenditure, which I don't think we disagree with. Yes. I'm not sure it turns actually on, was it something they were entitled to do? It's a hard-edged question of law.
You took issue with 2 points of principle that
Yes.
Parry made in her submissions. As I understood her submissions, looking at the outer circle of the dartboard, one of the points she made, I think, was what was going on there was for the purpose, or perhaps clarified, had the effect of enabling the taxpayer to decide whether or not to go ahead at all. It was nothing to do with the provision of plant for that reason. What do you say about that?
Well, that's another reason why it's very important when dealing with the facts to go back to what the FTT actually said, because there was a submission made to that effect by HMRC before the FTT. I think this was the category of expenditure that my own friend Miss Parry made that submission in relation to. At internal page 56, bundle page 476, paragraph 201. This is a discussion of the geophysical and geotechnical studies. And you'll recall there's the various stages of them. And at 202, well, actually, I think it's important to start at 201, because the finding is, I have no doubt that the evidence, both oral and documentary, and the findings of fact I have made in respect of that evidence clearly demonstrate that, as submitted by the appellants, the geophysical and geotechnical studies directly relate to the necessary design of both the wind farms as a whole and to the design of the individual wind turbines. This is the case for both the detailed geophysical and geotechnical studies and the reconnaissance studies. I say this for the same reason as to why I found that expenditure on the detailed metation studies qualifies for analysis. And then at the end of that paragraph, without that data, the wind turbines could not be specifically designed, and this, in my opinion, would have rendered them useless and unable to fulfill their function of generating electricity. Once they'd been so designed, each wind turbine had to be installed at a specific position in each wind farm, and so these studies directly related to the necessary design of the wind farms as a whole. And then at 202, I appreciate Miss Wilson's submissions that essentially the purpose of the reconnaissance studies was to assist in coming to a decision as to whether the wind farms were economically viable, rather than to their design or the design of the component wind turbines, and that they were undertaken at a time when the appellants had made no firm commitment nor come to any decision that the projects would be followed through to their conclusion. But the acid test is whether the expenditure on these products and studies directly relates to the necessary design of the wind farms or the wind turbines, and it is the effect of that expenditure rather than its purpose which is the legal test. The evidence in connection with the reconnaissance studies is that whilst they might have had an impact on the layout of the site within the options presented by the Crown Estate, the information gleaned from them was factored into the computer models which ultimately formed the basis of the necessary design of the configuration of the wind farms and to the design of each particular wind turbine. So the FTT had that submission made to it and made those findings.
Is it necessarily quite answering the point? I mean, suppose I carry out a study for purpose A, which happens to, the result of which happens to include information relevant to me when I'm doing something completely different. That wouldn't mean that what I'd spent on the first study had anything to do with, it should qualify for allowances in relation to purpose B, should it?
But the difficulty is then when one's talking about purposes.
Yes.
Because the question posed by the legislation is whether this is expenditure on the provision of the plant. And give or take a nuance maybe, that, as I understood it, was the revenue's position, that if the expenditure properly qualifies as being on the provision of plant, it does not matter that it might have been incurred for a different purpose or it might have served some other purpose. There is no duality. That was a submission that was made to the FTT and accepted. It's not been revisited by HMRC. And my learned friend says, well, there should be an apportionment. I'm not aware of the provision that would permit that. Maybe there is scope for that. I don't know, but that is a novel point.
And I see your point about effects and purposes. But there must be some limit to it, mustn't there? Surely. I mean, if you do something for a completely different reason, and that you happen to get a document that contains something that is then useful to you when you set about some new project, can you really claim any of the cost of the first thing? I mean, there might be years between the two events.
You have to assess the expenditure on the facts. I mean, the question is it on the provision of? If the answer to that is no, then it doesn't qualify. I mean, but trying to search for the answer to that is basically the search that we are engaged in, and one has to examine what the plant is and what it took to provide it. And if that was part of its provision, then yes, it would qualify. It is not a purpose test. There's no subjectivity to it.
I can't think of a sort of real-world example.
Well, it may be that one would crop up at some point, but that's not what's going on here, because the sole focus of the appellants is always on a wind farm. That's exactly what they intended to build. So all of this, all of these points about, well, it's decision-making and it's not in, you haven't got a conception of what you'd like to build and so on, they don't match the facts, because the appellants are in the business of producing electricity from wind, and they know what they are doing. There are points of detail that need to be factored in, and those points of detail are extremely important. That's what the design stage is about. But they know, they're not thinking, shall we build a car park or a marina or something. It's always going to be a wind farm. And linked to that comes back a bit to the necessary, unnecessary expenditure. There are things without which turbines can't stand up, like the foundations, and that's what really attracted the FTT. But there are things like lights and other peripheral parts that are attached to the turbines, like the gantries or the landings and so on. They all serve a purpose. These appellants are commercial entities. They are not in the business of painting turbines yellow because that's the managing director's favourite colour, or they would like a particular light on there for entertainment purposes. These things are miles out at sea. Everything is done because it's considered commercially necessary. And that's true of all of these costs. And my learned friend, Miss Parry, tried to portion the costs into two baskets: environmental studies, which she said is really about consents and things you have to do under the regulation, and then metocean, geophysical and geotechnical studies, which she puts into a different basket. But in reality, they're all about design, because the whole point of the environmental studies is to make sure that the physical asset that is going to be put into the sea is best suited to the environment in which it's going to sit. So all of them are really about design, because they're all about the impact of this physical asset and how it interacts with the environment around it.
Just to give a very simple example, probably too simple, but to see if it reflects reality at all, and picking up on the outer circle as opposed to the inner circles. Let's say at the outer circle stage, a survey is done of the seabed to see whether there are any unexploded ordnances at a high-level sense. The purpose being to decide whether to go ahead at all, because if you find it's littered with them, you're simply going to abandon the project. And what you find is, no, there's a little bit here and there, but that's fine, we'll go ahead. Which means at a later stage, you then have to do a much more detailed survey, which feeds directly into where you position the turbines and how you install them. It could be said the first one doesn't, although it feeds into the second one in the sense that it provides some evidence of where you need to look, it's too remote, too indirect a connection with actually provision of plant. And given its purpose and effect was, do we go ahead at all? It's outside, it's beyond the limits. Does that reflect anything that happened in reality here? And if so, is it a reasonable distinction?
As to whether it reflected the actual reality, I think the answer to that is probably no. That's not the way in which they would check for those things, although there are checks that are done that may have revealed that. But there are two issues that I'd take with that, my lord. The first is that we're back to the difficulty of sort of comfort blanket of talking about things as being too remote. That sounds like it would be helpful, but it's just a statement of conclusion. There's no principle about remote. What does it mean to be too remote, apart from not qualifying? How does one identify remoteness? Remoteness is a relative concept of the distance between two things. Where does one go from that? Now, on the specific example, and this is the second point, if there's a study that's done which reveals where the ordnance is, unless that study is put in the bin, that feeds into where you're going to install. It is as valuable as the study that's done by the third-party installer immediately before the monopile is driven into the ground. In fact, it's more valuable for the reason that I gave, which is that if one is finding out whether there's a bomb at the time of trying to hammer the monopile into the ground, it's not that helpful. One needs to know in advance. So on that specific example, that would appear in my submission to be qualifying.
Is it really right that remoteness is always just a conclusion rather than a principle? It may be hard to articulate, but it's usually got quite a lot to do with causation, hasn't it? When you say something is too remote, you quite often mean, yes, you could piece together a kind of chain of but-for events, each of which, none of which could have happened without the predecessor. But that in itself isn't enough. There has to be some stronger form of causal link if you're not to treat something as being too remote.
But in a way, my lord has just encapsulated the comparative difficulty, because there's a whole body of case law on what remoteness means. It's not just a statement by somebody that it's too remote. There's an underlying point about the difference between legal causation and foreseeability and so on. There is meat on the bones of that principle.
Mm.
There is no equivalent here, and as I submitted in the opening, there is a danger in my submission of thinking that because remoteness is a fleshed out concept in another area of the law, that it can fulfill an equally valuable function here. And all they have in common is the name. And really all one has is, by way of authority, is the reference to the word remote used once by Lord Wilberforce in Benedetto. It's very difficult to get a lot from that. And one can see, my lord's point, that remoteness might encapsulate what the judges are groping for. But again, that doesn't really help. It's a sense. Well, that has to be, difficult though it is, embodied into some principle. And allied to that is the difficulty that, with my respectful submission, Lord Reed and the other members of the House of Lords wisely avoided, which is the temptation to try and give a bright line test, which is what the Upper Tribunal has done.
But I mean, everyone accepts it has to be a dividing line at some point, don't they? And in that case, it must, if one can't in principle express what the nature of the divide is, then the test becomes impossible to apply.
Is that so, my lord? Because in revenue capital is a
Yes,
perfectly
as
fine
you
example. I think there's a case, it might be Lord Denning, who said that the difference between revenue and capital is a bit like the difference between red and orange or day and night.
Yes.
There are categories that everyone can agree on, and then there are bits in the middle where reasonable minds will differ. The fact that it's difficult to decide which side of the line or other it goes to doesn't mean that there isn't a valid test. And the temptation to lay down a bright line, in my respectful submission, to be resisted. The correct approach is to reason by extension from what we have got.
But have you not actually put forward relatively bright line tests? The question is whether they're right.
I would like to think, my lord, that the appellants haven't tried to do that. The appellant's essential case is that rather like the expenditure in issue in Berkeley Curl, if it is a necessary preliminary to the creation of the plant, then it cannot be too remote, whatever that means. It cannot be on the wrong side of the line.
But the necessary preliminary is itself a sort of bright line test.
Well, it is, with respect, no, because the point about Berkeley Curl is that Lord Reed was not trying to specify exactly where the line is. He was saying wherever the line is, this expenditure is on the right side of it. And his lordship wasn't trying to spell out where the line is. All he was concluding was that this expenditure, wherever that line is on the right side of it. And that's, in my submission, what his lordship meant when he said expenditure of this kind cannot be too remote. Unless I can assess further, that's all I was proposing to say about ground one. So then I can be much briefer on grounds 2 and 3. There didn't appear to be a great deal between us on the law in terms of the test to be applied. The position of HMRC on this appears to be that the expenditure in question was on the acquisition of capital assets. The capital assets being said to be, I think, the studies themselves, the lease. It also appeared that my learned friend had said on acquiring plant and machinery and on effectively acquiring a trade. And then I think my learned friend said it would be also could be considered to be on the goodwill of that trade. So there's rather a number of assets there. Just dealing with the first point about the studies. Whether or not the studies are themselves capital assets is itself a question of law. There was no attempt to justify why they ought to be considered capital assets. Ordinarily, a capital asset is an asset that's used for the enduring benefit of the trade. Now, the trade here is generating electricity from wind. It's not clear how the studies are used for the enduring benefit of that trade. And there is no analysis anywhere in the decisions below as to why the studies should be considered capital assets. In my submission, they are not. As your lordships know, that the appellant's case on this is that the expenditure was on acquiring the wind farm and the plant and machinery, hence why it qualifies. Well, if my learned friend accepts that, then of course there's acceptance by HMRC in relation to the first point about section 11. Now, it's curious that the revenues case then jumps over the wind farm, if you like, to the trade. So the expenditure is not on the wind farm, it's gone to the trade, which necessarily can't be started until the wind farm has been acquired, and jumps yet further to the goodwill of the trade. Well, that just, in my submission, highlights the incoherency of HMRC's position in relation to Section 11 and the first ground. Now, as regards the lease, that can be a capital asset, I accept. But as I submitted, the studies weren't on a lease, the expenditure wasn't on a lease, and the geophysical and geotechnical and metocean studies had nothing at all to do with any consents process or regulatory process or the lease. So one is left in the position in my submission that unless the capital asset is the wind farm, it is rather difficult to see how the expenditure can be said to be on acquiring a capital asset. And it is not absolutely not the case that it's being submitted there's a binary position that if you don't qualify for allowances, your fallback is the revenue deduction. There are instances where you'd fail to qualify for allowances, but your expenditure would still be capital. For example, if what you've spent the money on doesn't qualify as plant. So if you spent money on premises, for example, and it turns out they're premises, that would still be expenditure on a capital asset. It wouldn't qualify for revenue deduction. It is not as crude a binary distinction as my learned friend suggests. And subject to your lordships, that's all I was proposing to say about ground 2. And then ground 3, first point on that is that when dealing with this in the course of my opening, I took your lordships to the tax return and also to the closure notice. And in case it is of assistance, we had put together, just as a side-by-side comparison, the extract from the tax return that relates to the figures in the closure notice, because it's a little bit easier to see what the adjustments are.
I think that would be welcome, yes please.
I'm grateful, my lord. We have shared this with HMRC, so I'll just hand up, if I may. So what has been done there is on the first page there is a table which extracts figures from the parts of the tax return. This one is for Walney. And in the square brackets are references to the documents in the bundle. And there are 3 entries in the table: qualifying expenditure, capital allowances claimed, which is the writing down allowance, and then the trading profit or loss, in this case loss. Then there's a column showing what was included in the return, a column setting out the amount as amended by the closure notice, and then the amount of the amendment in the final column. And then the following 2 pages set out next to each other page from the tax return, and then the calculation that's done in the closure notice. And the right-hand page on both the second and third pages is the same. What changes is the page from the tax return. And on that second page, just dealing first of all with box 121, your lordships have that bottom left-hand corner, which has this is the total amount of the pool. 969,097,848. And then looking over to the closure notice, it's about 2/3 of the way down the page. Qualifying expenditure on plant and machinery, other, including any excess of AIA limit, 969,097,848. So that's the same figure. What is different, so what was amended, is the figure that is in box 107. The 187,423,524 figure. And that is amended under the heading Allowances in Trading Profits or Losses, Machinery and Plant Main Pool, which is the description given in the box. That's amended down to 171,846,835. So that is a reduction of 15.6 million. And then over the page, box 122 on the left-hand side, the first box, has the figure of 216,626,188. That figure is reduced over on the right-hand side under the heading Losses, Deficits and Excess Amounts, Amounts Arising Trading Losses, 201,049,499. And the difference between those two figures is the 15.5 million. It's taken off the writing down allowance. So what that shows is that the figure in the pool is not amended. Now, my learned friend's submissions on this, or at least in terms of the points that are in dispute, focused on section 50 of TMA. And the submission was that there was no reason to read into section 50 that all the tribunal could do is increase or reduce the assessment or the amendment. With respect to my learned friend, that is the wrong way of looking at it. It is not a question of the appellant trying to read something into section 50. It's HMRC that would need to read something into section 50. It's not a case that the tribunal has an inherent jurisdiction or inherent set of powers, and the question is whether the statute cuts them down. The statute creates the powers, so if it can't be found in the section, then it doesn't exist. Now, my learned friend's construction of section 50 which would depend on the application of section 48 and as to which there was a sense of perhaps a sense that HMRC didn't feel that section 48 was in fact in point. If that is the case, then there is no source of a power to make modifications to section 50. But on the case where section 48 is in play, what's required is necessary modifications to allow those provisions to operate in respect of appeals that are not against assessments. And as I submitted in opening, the extent of the modifications that are permitted don't go further than that. What my learned friend would suggest happens to section 50, which is page 37 of the authorities bundle. Behind tab 5 is, I think that effectively you can read self-assessment as tax return, and you can read increase or reduce as amend, and I'm not sure if any change was suggested to overcharged or undercharged, but that wouldn't seem to fit either. The conclusion seems to be that one ends up rewriting the section around the opening words. Now, there are two further oddities with that. One doesn't appeal against a tax return. But there's also the oddity of this, that a self-assessment is defined, as I showed you, Lordships, it's defined in paragraph 7 of Schedule 18. It is also defined in a similar way in the TMA in Section 9. And the self-assessment is an assessment of the tax due on the basis of the information contained in the return. So the self-assessment is not a synonym for the return. It is a discrete part of the return. And it's an assessment of the liability. It is a number. Now, on my learned friend's construction, if one is dealing with an appeal against an amendment, Section 48 would have the effect that the whole tax return would be up for grabs. And Section 50 would permit amendment of that tax return because you can read assessment as tax return and you can read increase or reduce as amend. But that sets up a rather odd and stark contrast with a plain self-assessment, which is what's catered for by default in Section 50. Section 50, as it stands, is dealing with an appeal in relation to an assessment, and it doesn't require modification under Section 48. So one can't change the words of Section 50 so as to read it as if it were referring to a tax return and so on. So rather than aligning the position, which is the clear purpose of Section 48, it creates a divergence. Because the powers of the tribunal in relation to an appeal against an amendment would then be much broader, far more far-reaching than the basic situation that's dealt with by default by Section 50. Now, as I said in my opening, I can understand why that is considered to be, or lead to, conclusion which might on the face of it appear odd, but the source of the tribunal's powers is the section. And in my respectful submission, HMRC have not provided a reasoned or coherent basis for spelling out of that section a power to do what they require the tribunal to do, which is effectively go back, step into their shoes, and amend the return in a different way. Unless I can assist further, those are my submissions in reply.
No, I don't take any more questions, so thank you very much, Mr. Jones. Thank you very much indeed, in fact, to all three counsel for very helpful and clear submissions. you will be astonished to know that we're not going to give judgment here and now. You will receive the judgment in draft in the normal way. We'd be grateful if at that stage you would correct our English and typing, but that won't, of course, be an opportunity to re-argue the case. Could you also please at that stage seek to agree an order dealing with consequential matters? If there are any points on which you disagree, can we please have brief written submissions, and we would expect to deal with them in the order that we make. Finally, and I know you're all very familiar with this, I should just remind you of the importance attached to the embargo. I think you have very helpfully provided a list of those who should receive the draft. If you think of anybody else who should receive it, then obviously you need to come back to us, given the significance of the embargo. But I think it otherwise just remains to reiterate my thanks to Council and to thank also everybody else who I know will have been very much involved in all this. All rise now.
All rise and take